Good afternoon. Welcome to what is the fifth Tanfield Talk live event. I'm Daniel Dovar, and with my colleague James Castle, we'll be looking at informal variations to service charges, a matter that's taken on specific relevance given the financial difficulties many tenants face due to the coronavirus. At the end of our talk, we will be open for some questions and answers, and hopefully you can see down at the bottom of your screen where there's a bar. There's a facility there for you to put in questions that we will field, time permitting, and whether or not we like the look of those questions. Just a quick advert for next week. Kerry Bretherton QC and Gemma de Cordova will be speaking on parking and property law related matters, so tune in for that one as well. So today we are talking about ghosts in the service charge machinery, and what do we mean by that? Well, we're looking at two broad aspects here. One is, when can the service charge machinery that's been carefully, although sometimes confusingly, been set out in the lease, when can that be overridden by other arrangements between the parties? And when that service charge machinery has been overridden and when the parties have adopted a different course of action, when can any changes be rolled back, such for example when the pandemic lessens or is over? So we will be dealing with two types of mechanisms for overriding the machinery, as we've said, again in broad terms, through representation or through common understanding. And I'll be dealing with representations, and James will be dealing later on with common understandings. And then we'll also look, as part of our consideration of those two aspects, the points about one-time waivers, if it's just a one-off, and also whether they are continuing waivers, and if they are continuing, how long they will last for, and is it possible to bring them to an end. Before getting into the issues of representation and common understanding, just to put things into a recent context, the government has issued a code of practice for the commercial property sector in order to try and facilitate and open up negotiations between landlord and tenant between payments under terms of the lease, mostly in regard to rent, but also they deal with issues of service charge. And it's those sort of negotiations and those accommodations that are arrived at which interface quite nicely with this talk, because it's those temporary arrangements that we're giving consideration to. So what I'd like to do is just to run through a few of those with you that are listed, so you can get an idea as to how the aspects of this talk are relevant, and also to make sure that you're familiar when advising clients as to the options that are available to them. So, of course, the obvious first one is where it's agreed that a full or partial rent can be paid, and what the government there in the code of practice say, free for a free period of rent or a set number of payment periods. We'll be moving on in a moment to a case which dealt with that issue, but in the context of the Second World War. And one of the points there was, when would payment or full payment restart? And what's being suggested here in the code of practice is that it's defined. If a rent-free period is going to be given, you should define the period and when the payment should start again. And then, rather than a waiver of rent, either full or partial waiver of rent, there could be a deferral of the whole or part of the rent for one or more payment periods. Again, it's important, if accommodation is going to be reached, that the parties are clear as to the basis and the timing upon which the deferred payment falls due. So that's in relation to the amounts that are due. The next point, the third point, is the payment of rent over shorter payment periods for a set time, over, for example, monthly rather than quarterly, including for provision for payment in arrears. So we're not talking about the amount so much here as changing what the terms, moving from what the terms of the lease say as to the periods of payment. Most leases will deal with it, say, in a quarterly basis, but it may be that the parties agree temporarily then to deal with it on a monthly basis. And so you can see you're moving from the strict terms of the lease to an informal arrangement. The fourth is to do with variations on the amount of rent to reduce ongoing payments. It might be to do with turnover on site, or to accommodate periods for which the site was closed. And the penultimate point here is landlords drawing from rent deposits on the understanding that the landlord will not then require that deposits be topped up by the tenant before, and this is the wording from the Code of Practice, it is realistic and reasonable to do so. I think you can already see that that form of wording may open up some form of dispute as to when it's realistic and reasonable to do so. And again, if these temporary measures are going to be put in place, then it's important to define what is happening and when it will come to an end. So, and the final part deals with negotiated agreement in relation to a portfolio. Maybe the landlord and tenant have a number of sites that they are in a relationship about. If it's done over a number of sites, it may make it harder to roll back the position because it's not linked to one specific site, and there may be some shifts between how different sites are treated. So again, care needs to be taken there. Just finishing up then on some of the other points. What you have as the first here is in the Code of Practice that landlords waiving the contractual default interest on unpaid rents or rent paid in arrears to make payment plans more affordable. And presumably that they're intended there is a complete waiver of the interest, not a deferment of that. And when you have an important point that we'll come back to later on is the fourth one here that I've set out in bold, is what can be seen as sort of quid pro quo. And what's said there is that any of the above, so sort of the rent cushioning or the service charge cushioning, in return for other arrangements, what can the tenant provide the landlord with? So here is a reversionary lease on reasonable terms, the removal of a break right in favour of the tenant, or an extension of the lease. So the negotiation is on the basis where the landlord realises, I don't want a void, I want to retain the tenant. If I go soft on the rent or the service charge at the moment, can I get something out of that? It may be that I have faith in the business there, and after the pandemic is over, the business will thrive again. I want to secure this tenant going forward longer than the current term, or certainly I don't want the tenant exercising a break. And so that may be a form of the negotiation. If that is right, then as we'll see later on, it might be harder to roll back certain elements of the cushioning. And there is in the Code of Practice also the specific mention of service charges, and the specific mention there is possibly the frequency of the payments should be spread over shorter periods. There's a similar point that's made in relation to rent. The general approach, though, in the Code of Practice for service charges is more that these should be paid because the buildings essentially need maintenance. So it seems the approach there is that it's less likely to go soft. So with that relevant context in mind, let's move a little bit further back then, and let's go to one of the first avenues by which the machinery can be avoided, and that's through a representation. And in simple terms, which we'll deal with in a bit more detail, A represents to B. Normally it's the landlord representing to the tenant that they will not avail themselves of a right, and then they're held to that representation. And as we put here, it's more likely to be a temporary arrangement than that's entered into during the current pandemic. So when will they be held to their representation? Well, before we get to that, this usually works when you have an audience in front of you who can shout back. I normally ask at this point, anyone know what this property is? And usually some people come back with a recognition of the fact that this is in fact High Tree's house, not far from me, as I am currently speaking from home, across Clapham Common. And the relevance of High Trees is the case of Central London Property Trust Limited and High Trees House Limited. And the background facts were, it was built about 80 years ago. It wasn't a pandemic that was the problem there, but it was the Second World War, a result of which led to a drop-off in take-up of leaseholders. But a head lease had already been granted for 99 years at a ground rent of £2,500. But the head lessee was unable to populate, as I've said, the building because of the war. And so in 1940, the parties, the freeholder and the head lessee, agreed to reduce the ground rent to £1,250 per annum. They halved it. Roll forward to the towards the end of the war in 1945, and the whole property had been fully let. The reason for the discount had ended, but there became a dispute as to whether or not they could revert to the full amount, whether the landlord could now claim £2,500 per annum or whether it was still limited to 1,250. Now, the case says that they, in order to resolve this, they started friendly proceedings. Now, I'm not sure if that's at that time was a formal procedure, but certainly that's how they are couched. The head lessee contended that the reduction was for the entire 99-year term. So that puts it in the context of the dispute. Now, Mr. Justice Denning, as he then was the judge, and he approached it on the following basis. He said traditionally, under the old common law, because this was a lease under seal, you couldn't vary it. That the ground rent was £2,500, and the fact that they had agreed something otherwise, whether in writing or by parole, was irrelevant. You couldn't do it. You couldn't vary it. You could only do that by deed. But he then looked at the position in equity, and he said, oh, well, in equity, that the old common law position has been softened slightly because you can do a variation by a simple contract. But the difficulty there was that there was no consideration for that contract. Here, it was just the head lessee was getting the property for half the rent. Where was the consideration from the head lessee? So he didn't find that equity availed. And what we now recognise as estoppel was the basis upon which, a form of estoppel, was the basis upon which he decided the case. And he said that it was a promise made which was intended to create legal relations, and that the landlord knew it was going to be acted on by the tenant, and, to quote, the promise must be honoured. And on that basis, he found that the lease, the strict terms of the lease, could be overridden in those circumstances. But it was important to look at the scope. And what was there was that the promise was that rent would be reduced as a temporary expedient to £1,250 a year, whilst it was not fully or substantially fully let, owing to the conditions then prevailing, being the war. And so that applied up until early in 1945, when the property was let out. So, and this is a point that we'll come back to. When does the variation of the service charge machinery come to an end? Well, in this case, it was when the condition came to an end, and the condition being the understanding between the parties was being effectively until the flat was fully or substantially, or the building was fully or substantially let out. He does refer later on to estoppel cases explicitly in that decision, and he said, well, you have to look at the conditions as to when the representation was made and the change was made, and either when that condition ceased to apply, would it revert back to the old, or it may be that notice is required. And again, we'll come back to that point later on. So that's the first case, which sort of sets up the situation that we are discussing here, and which is particularly relevant in today's environment as to temporary expediencies between landlord and tenant to overcome financial difficulties. The next case on representation is one called Brycom Investments and Car. So we're rolling forward a little bit, and this finds Mr. Justice Denning as the master of the rolls now, higher up, dealing with a similar case between landlord and tenant. But here we're moving on to a case which is directly on service charges. And in this case, the landlord wanted to sell off long leases of the building, but it was obvious to everyone that the roof was in dire need of repair. And those who were interested in buying the leases formed a residents association because they were concerned about the disrepair of the roof and the payment. Under the terms of the lease that they were to take, the landlord had an obligation to repair the roof, but the tenants would have to pay for that through the service charge to cover the cost of that, and that's what they were concerned about. in order to enable the leases to be sold, the landlord gave, first of all, the Residents' Association chair an oral assurance that it would repair the roofs, but wouldn't seek a contribution for this repair from the tenants under the service charge. So that was an oral assurance. And the chairman communicated that onwards to all of the flats and those interested in purchasing the flats. Some of the purchasers, though, some of the people who went on to purchase, weren't happy with that and didn't think that gave them enough security. So some of them got a separate written assurance, and others just relied upon the communication from the chairman. And you can probably guess what's happening, what's going to happen next, and why the case went to court, because the following summer, the landlord carried out repairs to the roof, but then issued demands under the lease for the service charge for the repairs. And he then brought a claim against the tenants who wouldn't pay. But as it says in the report, the landlord carefully selected who they sued. They only sued those who didn't have anything in writing, only those who had an oral assurance. So those ones who were more cautious and had gone to get an assurance directly from the landlord didn't end up being sued. And so what we have is we had, and to complicate matters slightly more, we had subsequent assignments of some of the terms of the leases. So within those who were being claimed against, we have A, B, and C. A were original lessees. They'd received an oral assurance from the landlord's selling agents, and they knew of the assurance to the Residents' Association before they took the lease. And then you had assignees of the original lessees who were told also of the landlord's assurance before taking the assignment. And then you had an assignee from the first assignee who entered after the roofs had been repaired and whose predecessors had received or knew of the assurances before taking assignment. Again, at this point, I normally take a show of hands from those who can recover. And I think we're not on Zoom at the moment, so I can't even get you all to raise your hands as to who thinks we could recover from A, B, or C, but make a mental note and then see if you're right or not. Well, it was found that A, B, and C could all rely on the assurance and didn't have to pay the sums demanded. So Denning, as I said now, who was master of the rolls, rolled forward what he'd said in High Trees, and he dealt with now what it was phrased as the doctrine of promissory estoppel. And in each and every case, he found for A, B, and C. And in relation to the assignees, he said the burden and the benefit run down the line of a signer or an assignee on each side. So he didn't see that was problematic at all. And it's also interesting in terms of the, as we said, the careful selection of who to sue. He noted that they'd been careful in only suing those who hadn't received a written assurance, but had received, but proceeded to sue those who'd received an oral assurance. And he thought that distinction was bad in law. And he thought if it was debarred for a written undertaking, it could equally debarred for an oral promise. So there is no magic in the writing in these circumstances. The only issue that may arise because of that is that it may be an evidential point that you have to prove, which may be a little bit harder if you haven't got something in writing. What was also interesting, though, was that the other two Lord Justices, Roskill and Cumming-Bruce, were less comfortable with the use of what they saw an expansion of promissory estoppel in this case, and instead how they cast it was a contractual variation of the strict contractual rights. They said it was a collateral contract that was entered into. That was with the original lessees. With the others, they put it in terms that it was a waiver, and that equity would relieve them from the consequences of the strict adherence to the letter of the lease. So it was a waiver in equity. So, bringing things to more recent developments, it's important to distinguish between two kinds of cases when the pandemic comes to an end. One, those where the landlord has entered into a specific arrangement with one tenant, limited to that, and the other tenants can't jump on that. It's limited to the one tenant. But if a general assurance has been given to a group of tenants, as in Brycom, then they can rely on it even if the landlord has not directly communicated with that particular tenant. And the last case I want to deal with on this subject of representation, again to bring matters up to date, because we're dealing with a case now of the Upper Tribunal in 2017, and also on another aspect of service charges that you may well come across, is the case of Southwark LBC and Akhtar. So this wasn't about the payment per se, it was about the mechanism that was used, and often there's a requirement for certification of some professional or other before service charges are due, and it's something that James will touch on a bit later on. In this case, there was, again, as is common, the facility for interim charges, quarterly interim charges in this case, with a reconciliation at the end of the accounting year and a surplus or deficit, depending on whether the actual costs exceeded the amount that was demanded in advance. In this case, as it was found, the landlord had failed to give proper notice for the charges in a year for the interim charges, and so they'd lost the ability to recover any payments on advance. But it was said that didn't prevent them from going to the end of year reconciliation or the end of year final demand charge on the actual amounts. So the interim service charge demand was invalid and they couldn't rely on those. They had to make a final demand instead. One other aspect of this case is that the landlord had set up a separate regime outside of the lease to defer service charge contributions. And what was said is that you can pay a bit later, but what you have to do is you have to give me a charge over your lease. So that was the offer to the tenant to say, look, you know, we'll change the strict term of the lease, but you need to give me security. And the tenant in this case, Akhtar, availed herself of that. She said, okay, I will, I'll get into the scheme, I'll defer the payment, and I'll give you a charge. But she then challenged the sums. She challenged the sums on the basis we've seen that the interim demands, which is what the landlord was relying on, weren't actually valid because they hadn't been presented in time. So she challenged the sum. And Her Honour Judge Cook held that it's well established that waiver is a representation, as hence the title of this part of the talk, usually by conduct. That makes it clear that an irregularity is accepted. And an irregularity here we can extrapolate to not conforming with the strict terms of the lease. And in this case, there had certainly been correspondence and disagreement about the charge, and the tenant was well aware of the possibility of challenge in the FTT. Nevertheless, the tenant took up the step of charging her property with the payment, and her doing so in the context of the preceding disagreement was a clear statement of agreement to pay. The fact that the agreement was preceded by argument and that the landlord threatened proceedings to enforce payment does not detract from the eventual agreement. This was an obvious waiver. So Her Honour Judge Cook's reasoning is couched in terms of a classic waiver by conduct. And in this case, it was the tenant, not the landlord, who was waiving her rights to rely on the strict terms of the lease in terms of whether or not when the charges were valid or not. So what one can see here is that a party to a lease can waive the invalidity of an act of another party, rendering the act valid. So in this case, it was the invalid interim demands was waived by entering into the arrangement where there was an agreement for deferred payment subject to a charge. And so the parties can compromise to avoid the strict terms of their lease. And one could think that the landlord can set up the conditions necessary for a tenant to voluntarily perform an act that constitutes a waiver. So the landlord may simultaneously entice the tenant to waive invalidity whilst making legitimate threats. In this case, it was the threat to take the tenant to court if she didn't pay her service charges. But those threats won't invalidate the voluntary act, and that was the entering into the deferment arrangement. But the landlord shouldn't go too far in making threats, or it may open up a defence arising from improper pressure. But if the landlord is prepared to incentivise the tenant by giving them some sort of advantage, the landlord may cause its previously invalid acts to be retroactively validated. So what you might look for, as I mentioned earlier, is the quid pro quo. If landlords have taken a step during the pandemic to benefit their tenants, but in exchange for something in return, there may be a valid compromise of the terms of the lease that can be enforced. And going back to the code of practice, although it puts it round slightly the other way, where in the code of practice, when it mentions all the softenings for rent in particular, but it would also apply to service charges, and when we refer to the fact that any of the above can be done in return for other arrangements, such as a reversionary lease on reasonable terms, the removal of a break right in favour of the tenant, or an extension of the lease, you can see how that will lock in the parties much more firmly into this arrangement that overrides the strict terms of the lease. So I dealt with predominantly one side of overriding the strict terms of the lease and touched upon certain situations in which you can return to normal. And now we're going to look at different types of cases where the two proceed and on the basis of common understanding. And in that respect, I'll now mute myself and hand over to James.
Right, so representations are likely to be much more common during the pandemic, because you're often going to be dealing with a situation where the landlord functionally has more power and has the decision as to whether or not the landlord's going to grant some sort of abatement to the tenant. Common understanding perhaps may be less common, but is the alternative method by which parties, landlords and tenants, might come to some sort of compromise during the pandemic. And towards the end of my section of this talk, I'll provide an example of when it might be that the common understanding might be triggered. So the common understanding is where A and B here, so landlord and tenant, proceed on the basis of a shared understanding that's been communicated between them and are then unable to act inconsistently with it. And what we're going to see is that perhaps a key, if not the most key element of this, is that the shared understanding has to be expressly communicated between the parties. I'm going to start by looking at the principles for a common understanding that were set out in the case of Bucklich and Merchant Exchange Management Company Limited. I'm going to show you the principles set out in that case and then look at an earlier case first where these similar principles were applied before returning to Bucklich. So in Bucklich, the upper tribunal made clear that the common assumption has to be expressly shared between the parties A and B, and that the estopped party must be properly said to have assumed responsibility for the assumption by conveying that assumption to B and expecting B to rely upon it, and that B, usually the tenant here, must have relied upon the common assumption itself rather than acting in accordance with the view independently. So you can't just have a tenant say, oh, I relied upon this common understanding, and as a result, the landlord should be estopped if the tenant always would have acted in a particular way in any event. One of the things you'll notice here when looking at these principles is that I'm using the terms of estoppel and this idea of there being an assumption of responsibility, conveying that to the tenant, and that the tenant can't have come to the view independently. They all marry in very well with estoppel cases, and these are usually estoppels by convention when you're dealing with shared communications between parties. But in some of the cases, the upper tribunal or first tier tribunal have also conceptualized these as cases of waiver too, and that's because the principles overlap to a greater extent. So the last elements here are that the reliance has to have been in connection with a subsequent mutual dealing, and then that there must be some sort of suffering of detriment or conferring of a benefit in order for the tenant to be unable to go back and say, oh no, landlord, I'm going to, you're not allowed to assert your strict rights. So the first case then that I want to look at in detail is Clacy and Sanchez. Now, in Clacy and Sanchez, the core dispute between the parties was about whether or not provision of certified accounts was a condition precedent for payment. So service charge demands were made by the landlord, and the issue was whether or not the service charge demands were valid because the landlord hadn't provided certified accounts before then making the final service charge demand. What had happened is that 19 years before this litigation took place, there had been a meeting between the landlord and all of the previous lessees of the block, at which an understanding was reached between them expressly at this meeting that the certification wouldn't be required, and that whatever the lease said, that would not be applied, or if there was a requirement to certify the accounts. And this was done in order to save cost and time. If the landlord was incurring the cost of certifying the accounts, this would be passed on to the tenants, and the tenants in the end didn't want to have to pay for that. Now, the upper tribunal decided that there were then two potential ways of examining what had happened at that meeting 19 years ago. The first was that there was an agreement based upon a common understanding. This is because both landlord and tenant had acted upon an assumed state of fact or law, the assumed state being certified accounts are not going to be provided before service charge demands are made. It's important to note, though, that the upper tribunal concluded that there was no representation or promise or concluded agreement. It was instead that there was a shared assumption. And it was important that it wasn't just that both parties were acting upon this shared assumption independently, but that it had been communicated by landlord to tenant, or by tenant to landlord. And so both sides knew that they were both proceeding on the basis of this shared understanding. In the light of the fact that that had happened at that meeting 19 years before, the upper tribunal ruled that it would therefore be unjust to allow the lessees to resile from the course of conduct, that certification would not be required, and that they should be precluded from doing so. The landlord has suffered detriment, and the tenants would be unjustly enriched if they did not have to pay for the benefits to which they had willingly accepted. In essence, the tenants had turned around and said, we don't have to pay our service charges because you've not provided us with certified accounts before you sent us demands, and as a result had received all of the benefit, but were trying not to pay their service charge. And the upper tribunal wasn't having any of that. The alternative, the upper tribunal found, was that there had been a waiver by the original lessees of their rights to resile from that position and insist that certification was a precondition of their liability. Now, similarly with the Brickham case, it wasn't actually in dispute in this case whether or not any estoppel or waiver had bound the successors entitled to the original lessees. And that's likely because it was made clear by Lord Denning in the Brickham case that the benefit and burden of the estoppel ran with the estoppel. So the successors entitled here wouldn't have really had a good argument that because they were successors entitled, they weren't fixed with the burden of this estoppel. There wasn't, however, in Clacy, a real argument about subsequently to what extent tenants could turn around to the landlord and say, well, we now require you to certify the accounts. There wasn't a debate about whether or not they could do that, and there wasn't an argument about what a period of reasonable notice would have been. Perhaps this is because this dispute concerned historic service charge demands, and that no present demands were being litigated where the tenants had already made the point already. So the tenants hadn't made a form of implied withdrawal in respect of any of the demands that had been made by the landlord that were in dispute. However, humorously, the upper tribunal, after dealing extensively with this issue of estoppel, then looked at the lease itself, interpreted it, and found that it didn't really matter. The certification was not a condition precedent of the service charge demands being valid. So whilst the parties had spent quite a lot of money litigating over this point, in the end, it didn't matter. Their lease didn't even require it. So whilst the parties might have entered into a shared understanding on the basis that their lease had said it was a condition precedent, it wasn't a condition precedent. But what we can take away from Clacy is that it is open to landlords and tenants, even if mistaken as to what their leases actually say, to enter into very long-term agreements, not to strictly apply the terms of their lease based on a common understanding. This one was 19 years. The parties had been proceeding on an understanding that they thought that they were not properly applying the terms of their lease. So you can come into, you can enter into compromises that can last for quite a long time. Then we have the case of Buckledge, which was decided in the upper tribunal the year after Clacy. Now, what's important about Buckledge is that it was very clear that the lease did say that demands must be certified by an accountant. What's different is that this point wasn't actually raised by the tenants until the day of the trial in respect to the service charges, where counsel for the tenants then simply asserted that none of these service charges between the that had been levied by the landlord were in fact payable, because certification was a condition precedent to liability and no certification had been taken place. The landlords were in essence ambushed by this point. Importantly, there had been another case between Buckledge and the Merchant Exchange Management Company Limited a couple of years previously, and this point hadn't been taken then. So the parties had been proceeding on the basis, at least in respect of that litigation, that there wasn't a condition precedent. The way the first tier tribunal decided to deal with this was by asking the parties after the hearing had concluded to submit written submissions on the issue of how to interpret Clacy and whether or not there was an estoppel arising from the parties' conduct, or whether perhaps the tenants had waived their right to insist upon the condition precedent. What the first tier tribunal held, and keep in mind, of course, that I've made it clear from the beginning in respect of common assumptions that you need to ensure that there is an express sharing of the common assumption between the parties. Well, the first tier tribunal decided that there was a condition precedent and there was an estoppel or waiver. And this was because the tenants had been tenants for 11 years and that they were shareholders in the management company, but they'd never complained about the issue of certification. They said that unlike in Clacy, there hadn't been a clear meeting at which the issue of certification had been discussed. But what they took away from Clacy was the upper tribunal's conclusion that it wasn't a requirement of an estoppel by convention that there be a representation or a promise or a concluded agreement. And so the first tier tribunal decided, you have paragraph 34, which is what they drew from, that the doctrine of estoppel by convention may therefore apply with a party against whom the estoppel has been raised made no representational promise. But vitally, what they missed was this point about the understanding being shared between the parties, being common to them, and having been expressly shared between the parties so that both parties understood that this was the basis upon which they were proceeding. They'd just taken the snippet from Clacy that said you don't need a representation or a promise. They'd missed, the first tribunal, that there needed to be a shared assumption. So you're probably not surprised to find that the upper tribunal made very clear that the first tier tribunal had missed the point of Clacy altogether. The assumption had to be expressly communicated between the parties, which hadn't happened in the Buckledge case. Clacy was distinguished because of that very significant meeting that had happened 19 years before that litigation had taken place, at which a common understanding had been reached. The decision of the first tier tribunal in Buckledge was then remitted back to the first tier tribunal to be reconsidered. And it was considered absolutely key to the estoppel by convention that the assumption that founded the estoppel had been communicated between the parties. It really didn't matter whether or not it was independently believed by both parties, albeit erroneously, that certification was not required. You had to communicate that point. So, in the case of estoppels by convention or waivers based on common understandings, there has to be this element of communication. If there's no such element of communication, the tenant can't avoid the strict terms of their lease, as happened in Buckledge. How does this interact then with the present circumstances we find ourselves in? I've said that representations is the more likely scenario in the midst of the pandemic where the landlord has a lot of power. Well, a common understanding could be reached in circumstances where functionally the tenant also is the landlord. If you've got a case where there's shared ownership of the freehold, say a block has been enfranchised by collective enfranchisement, and the block is functionally run by the lessees, you might have a circumstance where at the beginning of the pandemic, a residents association or group of the lessees acting in their capacity as the management company may have got together say, socially distantly over Zoom, and have decided and have reached a common understanding between all who are present that the landlord, or they, in their capacities as the landlord, would start requiring service charges to be paid in smaller monthly instalments following the code of practice. Or alternatively might have decided something more drastic. They might have identified that there is in place a reserve fund, and that service charges might not be being charged for a period, and instead services would be paid out of the reserve fund until the pandemic either ends or is abated. So that's the kind of situation in which a common understanding, estoppel or waiver, might have taken place. So with that in mind, either a representation, usually made by a landlord, or a common understanding reached by, say, a group of tenants who are also the landlord. Once the pandemic has ended or been abated, how do we return back to normal? Well, if what was waived was a one-time event, you can't really do anything about that. That's done and dusted now. Although, as Dan has made clear, if there was some form of quid pro quo, it's likely that the other side of the quid pro quo can still be enforced. So that will endure past the pandemic. But if you've got a continuing waiver or a continuing estoppel, where a particular kind of obligation has been set to one side for a period or compromised for a period, that's the kind of obligation that we might see landlords and tenants now trying to work out how to unpick. If not now, perhaps they'll be looking at it from the 4th of July when businesses start to reopen, or a reasonable period after that. So the durability of the waiver is going to be the issue between the parties. In High Trees, it was relatively clear cut. You had a lease there that was for a term of 99 years, but the compromise was considered to be only until all of the flats were let, and they were all let by 1945. You could pick a specific date. The Code of Conduct has said that when waivers are entered into or estoppels are entered into between the parties, or compromises between the parties, I think is the wording used in the Code of Conduct, that the parties should try to pick a specific date on which that should end. But a lot of people have been entering into compromises on the more nebulous understanding that the temporary arrangements are going to be for the duration of the pandemic, or until the pandemic has been substantially abated. In those circumstances, it's going to be hard to nail down specifically when the intended end date was going to be. That's where we're more likely to be looking at cases of reasonable notice being much more relevant. What will constitute reasonable notice bringing an estoppel to an end is going to vary according to the facts of each case. And landlords are going to need to be very careful when they think about wanting to bring, say, a temporary measure that service charges are only being paid monthly in smaller instalments to an end. Because of course, if they try to bring that arrangement to an end on unreasonable notice, and then subsequently try to enforce that, they may have difficulty enforcing it because the tenants might be able to turn around and say, we weren't given reasonable notice, you can't enforce that until a period of that would have been reasonable would have expired. That may not cause difficulties immediately, because at the moment landlords are going to be finding generally enforcing, for example, the payment of service charges quite difficult, where still we have a moratorium on forfeiture until the 30th of September. But if you get a case where a landlord and a tenant have entered into a long-term agreement in respect of service charges until the 30th of September, but haven't put a specific date on it, and then in and around the 30th of September, the landlord turns around to the tenants and says, it's time you started paying all of your arrears of service charge now. If reasonable notice hadn't been given up to that point, and then the landlord tries to forfeit, the landlord might well find themselves in hot water because they hadn't given reasonable notice. So landlords are going to need to look very carefully at specifically what the terms of the arrangement they entered into were, and what's going to be reasonable to ask their tenants to do in the context of their tenant's business or the tenant's livelihoods or other circumstances, and try to identify probably a conservative date for which to give reasonable notice to, and say that we're going to start rolling back our compromise from that date. Because if it's not a conservative estimate, and if landlords start to take risks, as I said, they might find themselves in hot water. So on that note, we've come to the end of our material. So I will roll over to the last slide. And I think now, if there have been any questions asked, Dan and I should be able to answer the questions if they've been fielded.
So one has just come up. Would there also be an argument of res judicata issue estoppel in the upper tribunal case? I think that's a reference to, is it Clacy, where it had been dealt with already, maybe Bucklich, where there'd already been a case between the parties where it hadn't been mentioned. I would have thought yes, because at that point in time, if you have an opportunity to take a point and you don't take a point, then that's it. You're shut out from that. The only slight shade on that is that, of course, when we deal with service charges, we're dealing with usually you're dealing with, say, the next year's service charge. But I think underlying that was a more fundamental point that ought to have been taken. James, I don't know if you've got any views on that.
Yeah, from my understanding, I don't think the res judicata point was taken, but it's one that probably ought to have been taken. Both parties had proceeded on the basis that there was no condition precedent, and so service charges had been recovered, and that had been enshrined in a court order. The issue may be that if the point was never taken previously, never raised and never adjudicated on, that the res judicata issue estoppel might not arise, and that might have been the reason why it wasn't raised itself by the upper tribunal when it was considering that issue.
Just touching on the last part of your presentation, James, on the old normal, and also some of the issues that people need to address if they're thinking about entering into these arrangements. I mean, I think that the code of practice seems to try and draw out a slightly higher level of detail as to when it will end and how long it will last for the arrangements. But I mean, we've also got to think about matters such as what if there's a second spike? But in between hand, so 4th of July comes, businesses start to get back on their feet. People are open for business again. The economy starts to pick up, albeit probably quite slowly. But come the winter or time, there's a second spike and everything sort of closes down again, or we're into another position. Whether or not any of these arrangements will carry through, or whether any informal arrangement won't survive, albeit a slight upturn in the economy. I mean, it particularly, say, for example, if you're basing it on some sort of turnover rent or occupation. I think they're all matters that, if you're looking at it now, you try and accommodate.
Yes. The tricky thing is going to be that the code of conduct has been published relatively recently and is designed for parties to enter into more specific agreements. But the pandemic's been going on for quite a long time now, and many people will have already entered into agreements that are far less specific than the code of conduct had tried to identify the party should enter into. It may well be that people who followed the code of practice and have come up with specific dates will find that if a second spike hits, they're going to need to renegotiate. But parties who were less specific will be turning around to their landlords, well, tenants will be turning around to their landlords and saying that, well, the second peak is all part of the same pandemic. You were saying from the beginning that this would be a benefit that you'd be rolling out to us throughout the course of the pandemic. And just because there was a time during which the pandemic was substantially abated doesn't mean that for that period you're going to be able to recover service charges or rent from us. And those are going to be the tricky cases and the interesting ones for once the pandemic has truly come to an end, to see to what extent landlords might have been able to or might be trying to enforce temporary endings to temporary agreements in the midst of a first and second peak. Those are going to end up being tricky cases.
So I think a few people have queried about handouts for the webinar, and you can obtain a copy of the PowerPoint if you email events@tanfieldchambers.co.uk. I take it from that everyone is satisfied as to how the machinery of the service charge machinery can be overridden and how it can be rolled back. So I think we'll draw today's webinar to an end. And just to remind you then that next week, Kerry and Gemma are dealing on parking and property related matters. So thank you all very much for attending and listening in. Bye-bye.
Thank you. Yes. Bye-bye.